About ready to get started here. Welcome, everyone. Thank you for joining us today after the nice long holiday weekend. Here in Duluth, Minnesota, we have the crispness of fall is presenting itself in the breeze, which I'm very much appreciating. And we still have sun, so yay, the best of both worlds. So we're here today with Leslie Hagen, and she's going to talk to us about developing a collaborative response to violence against women in Indian country. And she is the National Indian Country Training Coordinator. And so she has a lot of valuable information to share with us in the next 90 minutes or so. So again, if you do have any questions or thoughts throughout, please feel free to add those. In consideration of that, I have a few housekeeping things to mention. This is a Zoom webinar, so that because of that, your videos are disabled, your audio is disabled at the time. However, we have the chat and the Q&A function. The best way to utilize is using the Q&A function. That's the easiest for us to see. And we can bring up those questions to Leslie as she's sharing her presentation. Alternatively, if you'd like and you'd like to speak your question, that's a beautiful thing as well. You just need to raise your hand, do the little raise hand emoji, and I will enable your microphone. And you can ask that question yourself. If you maybe have a more in-depth question that might require follow-up questions, that would be a way to do that. If you do have any technical issues, Holly Oden is standing by and she's willing to help you as best she can. So you can either directly chat her in the chat function within Zoom. If you have a larger technical issue that requires something outside of Zoom, maybe you get kicked off and you're not sure how to get back in or whatever the case might be, you can also email her, and it's hoden@mshoop.org. Again, she's standing by to help you with any of those sorts of things. So I'm going to let Leslie introduce herself, give us a little information about her background, and then dive into the topic at hand. Again, very excited to have you all here. I'm going to stop my screen share. Leslie, if you want to go ahead and share yours.
Okay, thank you.
You're very welcome.
There we go. Is it up there, Jill?
It sure is. You are good to go.
Great. Thank you so much. And thank you to Mending the Sacred Hoop for giving me this opportunity to spend some time with you this morning or this afternoon, depending on where you're located. I was in Michigan last week visiting my family, so I got a little bit of time to enjoy that cool Midwest winter, or excuse me, weather that Jill was mentioning. A little bit about my background. As I said, I am from Michigan originally. I got started as a prosecutor in the state system in Michigan back in 1990, very long time ago. And that was when I started working with tribes. I was fortunate enough to be appointed by the governor to a statewide board that was the fiduciary for a lot of the federal money that was coming into Michigan. And that board also set the policy for responding to domestic violence and sexual assault and stalking crimes in Michigan. The board is called the Michigan Domestic Violence Prevention and Treatment Board. So that was a terrific experience. And through that, I started working with the 12 federally recognized tribes in Michigan. Eventually, I left the state system and became an assistant U.S. attorney in the Western District of Michigan. The Western District of Michigan has 11 of the 12 federally recognized tribes within its jurisdiction, and I was the violent crime in Indian country prosecutor. So I spent a lot of time in the Upper Peninsula and working directly with those 11 tribes, prosecuting primarily domestic violence, sexual assault, child abuse. I also did child pornography crimes and started the district's human trafficking task force. In 2005, I went to Washington, D.C. for what was supposed to be a one-year temporary assignment. I ended up spending 5 years there. And then in 2010, I moved to Columbia, South Carolina to start the National Indian Country Training Initiative. So I want to show you, there is a picture of the National Advocacy Center. That's the building where I work. Hopefully some of you have had a chance to travel down there for training. Unfortunately, we have been closed because of the pandemic since March of 2020, but we have certainly ramped up our online training, and all of that training is free. When we're able to open back up and do residential training, that training is free also. And the Department of Justice also covers all travel-related expenses for students coming down to the National Advocacy Center to attend training. So again, it's a terrific opportunity to spend this time with you. Some of the things I want to cover today: the federal government relationship with tribes, which Holly told me a little bit about, those of you who are attending today. So I think that this is something that you're well versed in. We won't spend a lot of time on it. Savannah's Act, which the Department of Justice has some specific deliverables under that statute. And then I really want to spend the bulk of my time talking about some of the statutes that are used in federal court for violations of intimate partner violence in Indian country, and really focusing on sexual assault, domestic violence, strangulation, excuse me, and Gun Control Act violations. And then, time permitting, we'll talk a little bit about information sharing, because that is critically important that we work together. So this is, I just like this picture. Is some of you may be working like me, you know, you look great in the middle of the couch, and then if everybody could see what's off to the side, since most of us have been doing a lot of teleworking lately, I think this is a pretty accurate picture. It certainly is right now if you were to see my desk. So I'm glad that we have the ability to still connect and do good work together via technology. So as you all likely know, when it comes to the federal government and federally recognized Indian tribes, there are 574 federally recognized tribes in the US today. This is not a static number, it is fluid. It will continue to increase over time. Even since the last 20 years, there have been a number of tribes that have been added to this list. And we see them either getting recognition again through litigation or actions they've taken with the Department of the Interior. We've seen some tribes in the last couple of years that were recognized via congressional act. So again, this is a number that will continue to increase. The tribes that we have, of those 574, they're a mix of public law 280 and non-public law 280. And the non-public law 280 effort is really what I'm going to focus on today, because this is where the federal government has concurrent jurisdiction with that of the tribe to investigate and prosecute cases. If you are in a public law 280 jurisdiction, the state has a lot of responsibility to investigate and prosecute crime. And that is also concurrent with the tribe's own criminal justice system. But really my focus today, and my focus when I was in a prosecutor, I was in a non-public law 280 jurisdiction, and did have the responsibility and obligation to work with tribes to investigate and ultimately to prosecute many criminal violations, particularly those in the arena of violence against women, Native women, prosecuting those in federal court. And it is interesting when I do training with somebody that doesn't work in Indian country, and they're literally shocked to hear that there are 574 different federally recognized tribes in the US. And they are also surprised to learn about the sovereign status of tribes, and that they have their own governments, their own criminal and or civil court systems. And one of the things that I frequently get asked is, well, what is it, the blood quantum requirement to be Native American? And I'll say, well, I don't know. It depends, because it is not a racial or ethnic designation, it's a political designation. And it is ultimately up to the tribe to determine what are the criteria for recognizing a member of that particular tribe. One thing that is always important to remind myself and to remind my federal colleagues that may be new to working in Indian country is that we absolutely have a moral and legal duty to recognize and adhere the federal trust responsibility that we owe to tribes. And we are obligated to provide for public safety, education, healthcare, and that is part of that trust responsibility. And we also have a government to government relationship with tribes. So we as the federal government should not be making policy, passing laws, unless we have engaged in consultation with tribes that will be impacted by those policies and those laws. So this is a memorandum. The first time it was passed was in 2000, an executive order that came out of the White House in the Clinton administration, recognizing this government to government relationship. And I think every presidential administration since has put their own memo out on this topic. So you can see here, January 26th, the Biden administration put one out just right after the inauguration, talking about tribal consultation and our need to strengthen that nation-to-nation relationship. And this is something that is available on the internet if you would like to read it. Something that I wanted to call your attention to, I've already mentioned our need to engage in consultation and our trust responsibility relationship and recognizing tribes as sovereigns. Back in July of 2010, the Tribal Law and Order Act was passed. And this particular piece of legislation was passed after approximately 3 years of hearings conducted by Congress. And tribal leaders spoke again and again about failings that they perceived of the federal government to investigate and take cases of domestic violence seriously against Native women being, happening in Indian country, and many of those being committed by non-natives. They talked about not getting information from the federal government, not hearing about the status of cases. So the Tribal Law and Order Act, one of the goals of that was to really strengthen the responsibility of the federal and state governments to respond to tribes. So Section 212 of TLOA for short, requires that the Attorney General submit an annual report to Congress that details investigative efforts by the FBI and also the disposition of matters received by U.S. attorneys with Indian country responsibility. So according to TLOA, there are 4 types of case-specific declination information that has to be compiled and reported out. And since, as I understand, the majority of you work in Indian country, I thought that this might be of interest to you. So this report includes the types of crimes that are alleged to have been committed. We have to report out the status of the accused and also the victim, their Indian or non-Indian status, and what was the reason for either the FBI administratively closing the case or the U.S. Attorney's Office deciding to decline or terminate prosecution. And it is important to know that the FBI does have the ability to administratively close a case, and those cases may be unknown to the U.S. Attorney's Office. It doesn't mean that they were referred to the U.S. Attorney's Office for review. So this is what the report looks like. This is a public-facing document. This is the report from 2018. It's a little difficult to write the report because we keep track of things many times on a fiscal year basis, and the statute requires that this report be written on a calendar year basis, and typically it runs about a year behind. So this is what the cover of the 2018 report looks like, and I will show you where you can find that report. Here's a summary. So in calendar year 2018, U.S. Attorney's Offices resolved over 2,500 Indian country matters. The majority of those were resolved by prosecution. and the declination rate has remained fairly constant over a number of years. You can see there in the third bullet paragraph. So in 2018, there was 39% of those 2,500 plus cases were resolved by declination. And the most common reason for a case being declined was insufficient evidence. That was 64.3%. And that has remained over a number of years the reason that is used most often for declination. And the second reason most frequently used is the case was referred to another prosecuting authority. And typically that's where a case is referred back to the tribe to prosecute. So this shows you defendants' cases where Indian country program categories, either violent crime or nonviolent crime, was used. And you could see those numbers are also fairly constant. So there aren't any big swings that we see year to year in this data. And then the graph that shows declination reasons for Indian country crimes, you can see there it's displayed 64.3% insufficient evidence. Referred to a different jurisdiction, 17.9%. Again, that's likely referred back to the tribe. Legally barred might be where a statute of limitations has run, or I can remember a case that I was part of the investigation with a tribe, and when we got all of the facts, we found what we had a non-Indian defendant and we had a non-Indian victim. So neither the tribe or the federal government had jurisdiction of that case, and it was referred to the state. So that would be an example of a case being legally barred. This is probably the slide that would be of most interest to many of you, particularly those of you who are advocates, is this breaks out how cases are declined by type of crime. And again, this is 2018. And you can see down the left-hand side, I'm going to pick, well, let's pick Minnesota, the District of Minnesota, since Mending the Sacred Hoop is based in Minnesota. So you can see there in 2018, Minnesota, MN, declined 8 assault cases, 1 murder case, 4 sexual assault cases, and that includes both adult and child victims, 1 drug, alcohol, or other offense, no financial crimes, and the last category also nothing. So in 2018, there were 14 total cases declined. Now we see some districts, and the ones that we commonly refer to as the Big Five, where there's the most cases, are Arizona, New Mexico, Montana, North and South Dakota. So you could see much higher numbers in Arizona, 288 declinations, but they also prosecute many, many more cases than do a lot of other U.S. attorneys' offices. Same thing, you could see North Dakota, 102 declinations, but again, they're in that group where they're the U.S. attorneys' offices with the 5 U.S. attorneys' offices with the most Indian country cases. So this is the website where you can find that information, and there's a lot of other, excuse me, great information on that website. If you just Google tribal justice and safety, it should take you there, and there is the full address. This is what that page will look like when you go to it, and you can see down the left-hand side the second category, Tribal Law and Order Act. If you toggle on that, that is where you will find this Indian country prosecution investigation and prosecution report. And as I said, it's about a year behind, but you will see them dating back to the first report, which was a 2-year report written in calendar year 11 and 12. And a lot of other good information, grant information, VAW implementation, special domestic violence criminal jurisdiction. So I invite you to bookmark this page and then, you know, continue to look at it because you'll see a lot of good information there. So let's go into more of the topical, prosecuting cases part of the presentation. I don't have to tell you that violent crime in Indian country is experienced, particularly crimes of domestic violence and sexual assault, unfortunately can be greater than in other communities that we see in the US. This is a great report if you're looking for statistical information on the rates of victimization. It was written by Dr. Andre Rose, who at the time of the writing of this report was a fellow at the Department of Justice's National Institute of Justice, which is DOJ's research arm. The full report is 82 pages, but there's also a shorter summary that is available. And one of the things that is very nice about this report is the data is taken from the National Crime Victims Survey, but they oversampled American Indians and Alaska Natives. And they asked them questions about specific types of victimization, sexual assault, psychological abuse. There was 4 different areas that they looked at, and they asked them about their experiences with those types of violence over the course of a lifetime and in the past year. And what they found is that for men and women, it was in excess of 80% of those individuals that were a part of the survey that had experienced that type of violence over the course of their lifetime. So it really demonstrated that in fact, we are working with populations that unfortunately have experienced high rates of violent crime. This is what the report looks like. You can see there what was examined: psychological aggression, physical violence, stalking, and sexual violence. The report also looks at the impact of violence on the victims and the perceived race or ethnicity of the perpetrators. So again, important document. So I'd like to show a video. This is, I think, a great video. It's called Introduction to the Issues. It really focuses on sexual assault and particularly alcohol facilitated sexual assault. But I like it because it talks about the federal, this was a federal prosecution, federal working with tribal. It also talks about some of the issues that victims experience, like racism, shame, humiliation. I think it's a really, really powerful piece. And this was a training video I did a couple of years ago and filmed with Video Action, which is a production company in Washington, D.C. And just, they do very meaningful work and really, I think, just very solid training videos. Since, many of you are probably from the upper Midwest, you may recognize some individuals who are part of this video. I would just ask that, you be careful in sharing the information that you hear here. And I always want to honor and thank those who are willing to share their stories publicly. So hopefully this will play.
In the past 15 years, I would say I've talked to over 400 Native women who've been raped.
Leslie, if you could turn up your volume a little bit, I think that would help.
Okay.
Sexual assault is so common in some tribal communities that you will hear women say, I don't know anyone in my community who has not been a victim. It's not a matter of if you're raped, it's a matter of when. We
talk about the so-called date rape drugs, but by far the number one drug that's used to facilitate assaults is alcohol.
We were drinking, we were underage, and it was just a way of life, you know, at that age, partying and just drinking. I remember like waking up and I knew I got assaulted. It just felt so wrong and I just feel ugly.
It's important to not get so focused on the fact that she may have voluntarily consumed all of this alcohol. If it puts her in a state where she cannot consent to a sexual act, then you have what you need to prosecute the case.
Alcohol is used by most sex offenders for two main reasons. One, it's readily available, and two, it's socially acceptable.
One of the biggest myths is that when alcohol is involved in sexual assault, it's a spontaneous event. But I think in reality, we see cases where there's definitely some planning involved. They know that, for instance, this particular young woman has some challenges. Perhaps she's been abused as a child. Perhaps she has struggled herself with substance abuse, or comes from a home where alcohol is used frequently, and they target her. Now that I'm older, I see the truth behind it, and I thought it was safe in a family setting, and I really wasn't safe.
That intoxication not only allows the offender to take advantage and make that victim more vulnerable, but it also gives them a smoke screen. Well, I was drinking too. We were both drunk. It was just drunk sex.
I just never thought I would be victimized like this because I was so aware of the sexual violence on the reservation. We had to be careful who you drank with, you know, who was around and who knew you were drinking there, because there's a high chance that we were either going to get so intoxicated that you would pass out, and, you know, bad things happen to people all the time.
We typically only think of females, you know, being the victims of alcohol-facilitated sexual assaults, but many men fall to that same pattern of victimization, especially with alcohol.
Domestic violence, sexual assault, those were not traditional to our nations. You can point to numerous different factors, you know, colonization, the boarding school era, all of these historical traumas that have happened to our nations and that have shaped our evolution to where we are today.
A lot of my friends, family members have endured some kind of trauma, whether it was domestic violence, sexual assault, substance abuse, even mental health conditions. It was a very hush-hush issue, and it wasn't talked about.
We do have to acknowledge all of those historical traumas to figure out how to address them and then move forward in a positive direction.
There are many reasons why victims are reticent to come forward, and some of those are unique to Indian country. First and foremost is the sheer humiliation. This crime is like no other crime. It is sexual, it is painful.
My perpetrator was my brother's best friend's brother. So in reality, we're like family. It just took my whole spirit away. The easy part was wanting justice. The hard part was coming forward and trying to live through that shame.
Invariably, unfortunately, there will be family members who side with the victim and family members who side with the defendant. And it's due in large measure, I believe, because of the small nature of these communities.
As I try to heal, I have to understand that there's a bigger picture here. It's not just me that this is happening to. It's just like happening to everyone.
Hey ladies, introduction.
When Native women are in a place where they can talk about sexual assault, and somebody says, "What happened to you? You know, how did that happen?" And you'll see the responses, "Well, which time?" The most important service that can be provided to a victim who was assaulted while intoxicated is confidential advocacy. You can go talk to somebody and get information and get support without the fear that everybody in the community will hear your story. Having that service available allows the victim to consider all their options. And one of those options is to report the crime.
Prosecution is a vital component to that because it holds the offender accountable, gives the victim some sense of justice, that they were believed, they were listened to, and they were important.
That's the number one thing, is I believe you in what you're saying and not judge them right off in the beginning, because that's what happens in a lot of times.
For me, when I interview a victim, I want to give them space. I want to be able to let them know that it's okay not to, to relive everything at the moment. And I want the victim to know that we support them and we have services for them.
My aunt reassuring me, "We gotta go do this. You have to do a rape kit." And then I thought about the actual act of it. It was really traumatic. I was like, "I can't do that." She's like, "I'll go with you. Let's go. Do you want me to go with you?" And yeah.
When a patient comes in, I usually have a patient advocate come in who hooks them up with the right resources. I can refer them over to our behavioral health system, which we have numerous counselors for them. And usually I give them a medical forensic exam and prophylactically treat them for pregnancy and STIs.
For me, walking into the ER was really shameful because there's a stigma on a reservation that when this happens, you're like a whore. You're like a slut. You wanted it. There's a stigma there. So I didn't want anybody to know.
In this case, we had a great investigation, but we didn't have forensic evidence we could use. And so it really did come down to the victim. The most important way, I think, to build rapport, to build confidence, to build trust in you, for her to feel safe with you, because that courtroom will be scary and feel even dangerous, is to spend time with her.
Greg was really awesome in helping me in my case. And what I liked about Greg the most was he didn't have that sort of racism that's around this area. The racism around here is so high. And he was like, I loved it. He was just on this, "We're going to get this guy," just reassurance that he was going to do his job. And that felt good. That gave me a lot of confidence.
We never let her forget how well she did, how brave and courageous she was to come in there. And he was convicted of sexual abuse.
It's really important that tribal leaders express the philosophy that this kind of behavior, this sexually exploitive behavior, is not keeping with tribal tradition. It's not acceptable under tribal law. And we have a policy of believing survivors and supporting survivors. And that message coming from the top, I think, is critical.
I want the word to get out that, hey, we're serious. We're going to do something. you know, we want this to end.
Being a parent now, I have to tell my kids about this, you know, so that it empowers them. This ugly doesn't take away from you, it empowers you. I was perpetrated on numerous times, but this one time I have justice. This one time I had justice, so I believe in it.
So hopefully you could hear that. I know there's sometimes challenges between interfacing DOJ computer and Zoom, but I do think it is a very powerful video, and it really shows all of the different systems pulling together, because probably the first and perhaps the most important thing I learned as a young assistant U.S. attorney working in Indian country is that we are a team, and the feds can't do anything unless we work closely with the tribe, because the tribe is going to be the first responders for law enforcement, medical, advocacy, and it's almost never going to be the federal government, the FBI, that's going to be the first on the scene. So it's very, very important that we develop that close collaborative working relationship. That's the best thing for victims, that's the best thing for communities, and that is the best thing for justice. So the Savannah's Act I mentioned, I'm sure many of you are very familiar with, was signed into law in October of 2020, and it deals with the issue of missing or murdered Indigenous persons, and it deals with men, excuse me, women, and children. So what it is intended to do is clarifying the responsibilities of federal, state, tribal, and local law enforcement as to their respective roles. It is to increase coordination and communication amongst law enforcement agencies, and specifically should include medical examiners and coroners. It is intended to empower tribal governments with resources and information necessary to effectively respond to cases of MMIP. And it is intended to increase the collection of data. Data is always a difficult issue because so many of us use different systems, and those systems many times are voluntary, like NCIC, so getting accurate data is always a challenge. So at the Department of Justice, we have been working very hard. We have to get guidelines, investigation guidelines together for law enforcement. Those will be issued through the U.S. Attorney's Office. We're working on them at the DC level, and also I've been doing a tremendous amount of training on issues connected to MMIP. So hopefully you are getting notices of those trainings. We've got a big one next week. We have almost 1,000 people registered for a webinar that we're having the afternoons of September 14 through 16. This is the document, the executive order issued by the president in November of 2019 that established Operation Lady Justice that you may be familiar with. OLJ, as we call it for short, is also a part of the big national webinar that we are doing next week. They have a website where there is a lot of resource documents that are listed there, also links to some of the relevant laws, a report that they were required to prepare after their first year in existence. OLJ is set to sunset. It was a 2-year EO, so it is set to sunset in November, and there should be a host of additional products that are released prior to November. So you can see there is the sign that they're using for OLJ, very beautiful drawing by a Native American artist. One of the things that I did as part of the department's MMIP efforts is within the Office of Legal Education, where I work, the National Advocacy Center, we have a publications department, and we have what is sort of akin to a law review journal that comes out every other month, and they are dedicated to specific issues. So the January and March 2021 issues were both focused on MMIP related topics. And so I wrote a number of articles there. There's medical. You can see Jen Pierce Weeks, who's the CEO for IAFN, wrote an article on addressing issues of comorbidities in MMIP related work. There's law enforcement information, how to investigate missing, how to investigate unresolved homicide cases. So these are public facing. I encourage you to go there and look through. There's about 25 articles altogether. One of the things that I think was really, I was very proud of in putting these journals together is that it's not just written by a bunch of feds. We also reached out to Native experts and had them either co-author or author articles themselves. So you will see some articles on the use of culture in prevention.
Quick question. Oh, sorry,
Yes.
Leslie.
Oh,
There
no,
was a
please.
question in the chat. You, on the previous slide, you mentioned to sunsets. What was that in reference to?
Operation Lady Justice. So
Okay.
President Trump was the president who put out the executive order in 2019, and that executive order called for the Operation Lady Justice Task Force to live for 2 years. Now, it could be reauthorized or it could sunset and be replaced by something else. I think the big thing to take away from it all is that we are very invested in continuing the work. And Savannah's Act and the Not Invisible Act requires that we do many things to further the mission of missing or murdered Indigenous persons.
So when you use the term sunsets, the verbiage
Yes.
implies that it's ending, that particular initiative is
Yes.
ending, and maybe, okay, that was the question,
Yes.
just what the verbiage meant. Okay, thank you.
Yeah, sorry, sunset. It could be started anew. It could come back as something else, but the EO that President Trump signed was for 2 years. So I'm sorry for using that word if it was confusing.
Nope, that's great. Perfect clarification.
Okay.
Thank you.
Thank you for the questions.
Yeah.
So let's go through some common statutes that we use in federal court when we're responding to violent crime in Indian country, and particularly crimes of intimate partner violence. So sexual assault is something that we see, unfortunately, a fair amount of. So Chapter 109A in the federal code is where we have our sexual abuse statutes. And it is important that tribal law enforcement and tribal prosecutors, that they are also aware of the elements that are included in these statutes. Because again, many times it's going to be a tribal law enforcement officer who is the first responder, gets called to a clinic, gets called to a hospital, or to somebody's house after there's been a disclosure, and they're going to do some initial questioning. So it's very helpful if they have been trained in what the federal law requires, because particularly in a non-public law 280 jurisdiction, there is a significant chance that many of these cases will end up in the federal system. And we want to hopefully eliminate the need to re-interview victims many, many times. Excuse me. So part of the definitions in the statute that we want to be familiar with is there's sexual acts and sexual contact. So in the federal law, a sexual act is a penetration crime. And you could see there that can be established one of 4 different ways. Also important that penetration can be however slight. So really just very little penetration. Sometimes we have defendants who say, well, she says she's been digitally penetrated, use of a finger, and he says, no, I just, inadvertently brushed against her. Well, if in that, as he describes it, inadvertently brushing against her, even a smidgen of that finger penetrated the female genital opening, then that constitutes a sexual act. Sexual contact are touching offenses, and according to the statute, it's particular body parts. So you can see there and it can be over or under the clothing, the genitalia, anus, groin, breast, inner thigh, or buttocks. But we also have to show for sexual contact, what was the defendant's intent? So that intent by statute has to be an intent to abuse, humiliate, harass, degrade, or arouse or gratify the sexual desire of any person. And when I was charging sexual contact cases, typically what I alleged is the arouse or gratify the sexual desire of any person. And, in order to show that, we would get information during the course of the investigation about things that were said before or after the crime. Did the person have, if we had a male defendant, did the person have an erection? Did they ejaculate? Those are some of the things that we would look at to see what was the defendant's intent. Hearsay is an important concept when we're talking about litigating cases. Hearsay is an out-of-court statement that is offered to prove the truth of the matter asserted. And typically what we hear is that hearsay is inadmissible. We want to have the witness who actually saw something, heard something, experienced something coming into court and testifying about that. We don't want it filtered through 2 or 3 people because then it becomes unreliable. However, we do have some exceptions to this hearsay rule. And one important exception when we're talking about intimate partner violence crimes is if we have that victim, a sexual assault victim, a domestic violence victim, strangulation victim, if we have them seen by a clinician, there is a specific medical hearsay exception. And so statements that a victim makes to a medical provider, and those statements, the medical provider is asking questions, and questions go to medical diagnosis and treatment, those may be admissible in court. So if we have, let's say, a strangulation victim, and she is treated by an EMT, paramedic, taken and examined by somebody at a sexual assault nurse examiner program, that clinician, that medical provider is going to ask questions about what happened to you. Can you describe what happened? How were you assaulted? If it, again, using a strangulation case, well, how were you strangled? Was the person in front of you? Were they behind you? Did they use a ligature? Was it 1 hand, 2 hands? And they're asking those questions because that is going to help inform the treatment and the diagnosis of that patient. So one of the legal principles about why this type of hearsay information is admissible in court is the thinking is that if somebody goes to a doctor because they have been hurt, they don't feel well, that they are going to be honest with that medical provider. And it is that indicia of reliability, that's the words that are used in case law, that makes that testimony reliable. So that indicia of reliability. So you could see their statements made for purposes of medical diagnosis or treatment. And that can include a description of how they got hurt, what type of pain they're experiencing, and they are even allowed, the clinician is allowed to testify in court about who was the assailant. Because medical providers, before they discharge somebody, they have to make sure that they are not being discharged to an unsafe environment. So they need to know who was the person that committed the harm, who hurt that particular victim, so they're not sending them home with that individual without some type of safety plan or plan in place to keep them healthy. So as you can see there, this type of statement need not have been made to a physician. Case law shows statements have been made to hospital attendants, ambulance drivers, psychologists. I've used it with an MSW social worker. And the reason I bring up this hearsay exception is because I am assuming that many of you work on some type of collaborative body, a coordinated community response, and you may be developing a sexual assault nurse examiner program. Over the years, I have seen many SANE programs. Now those nurses are also seeing domestic violence patients routinely, and this medical hearsay exception applies. So then if we have a victim who recants, who minimizes, we can call that medical treatment provider to the witness stand and have them testify under this medical hearsay exception about what did the victim tell you happened to her? How did she get hurt? And who hurt her? Who committed the harm? All of that is perfectly legal. Again, because the nurse is not acting as part of the criminal justice investigatory body, it's because these statements are being made to the clinician for purposes of medical diagnosis and treatment. And that is an important thing to remember when you try to admit this kind of testimony. Another important thing that is very helpful in the federal system is Federal Rules of Evidence 413 and 414. Many times when we have domestic violence crimes, and sexual assault crimes rather, these aren't one-offs. I have worked cases where I did one case in the Upper Peninsula of Michigan. The defendant was 27 when we went to court, and we had identified 10 other victims that this particular defendant had in a very small community. So these weren't one-off crimes. This was somebody who was a sexual predator, took advantage of people that were intoxicated, took advantage of family members. And what this particular rule of evidence does is it lets us bring in those other crimes. So let's say you are an advocate working for a tribe. Let's say tribe A for our hypothetical. And you have lived in that community for a long period. You may even be a member of that tribe, and you know of John Doe, the defendant, and you've heard stories over the years about what John Doe has done to a half a dozen women or more. If John Doe is arrested on a crime that he committed last night, a sexual assault, it is possible for law enforcement to go to those previous 6 women, interview them, and use them as witnesses against John Doe. And when they testify about what John Doe did to them, that comes in as substantive evidence. So one of the things I would always ask when I went out to the reservation to interview victims or witnesses is, have you ever heard about John Doe doing this to anybody else? And I would say there was about an 80 to 85% chance that I got a yes answer. And then we would go interview those other victims. And sometimes we use them at trial. This isn't an ambush on the defense. We have to disclose the evidence that we have at least 15 days prior to trial. So you need to do this ahead of time. The reason behind this, 413 is for adult victims, 414 is for child victims. But you could see for adults, this was Senator Robert Dole at the time that this was passed many years ago, where adults are the victims. These cases often turn on difficult credibility determinations. And if a jury knew that the defendant committed rapes on other occasions, that would assist the jury into determining the plausibility of what the victim is now saying and eliminate what we always hate, what we hear about sexual assault cases. Well, it's a he said, she said, or as Senator Dole said, an unresolvable swearing match. So this is very, very powerful information. Here it is for 414, child molestation cases. This is a rule of admissibility. So it is more likely than not that these other earlier victims, that their testimony will be admitted. The court is still going to engage in a balancing analysis to make sure that the information is more probative than prejudicial. But this rule is a rule of inclusion. And in cases where I have used it, I've used it where there's been 20 years between the old case and the case that I was litigating in court. I have used earlier victims where they had not reported to the police before, or where they had reported and there had been nothing charged. The police had not really done a thorough investigation, or the prosecutor did not charge. So there does not have to be an earlier conviction. There does not have to be an earlier report. And case law shows that 20 or 30 years can lapse between the old case and the case that is being litigated now. So this is very, very powerful evidence. And my hope is that as we're working cases, we will build into our questioning of victims and witnesses that simple question, have you ever heard of John Doe doing anything like this before? I talked about the rules being time sensitive. Do the acts have to be the same kind of act? Again, case law gives a lot of latitude there. In the Tyndall case, one of the victims was 13, one of the victims was in her 60s, and what the court focused on was the defendant isolating the victims and said that that was similar enough. And so the victim in the earlier case was allowed to testify. So let's talk about amendments to the federal assault statute. So we see a lot of assault cases. It is in the Major Crimes Act, 113, felony assaults. So we can use these if we have a non-Indian who assaults an Indian person in Indian country. We also use these if we have Indian defendant and an Indian victim. And I'm using the word Indian because that is how it is used in statute. So assault with a dangerous weapon is where somebody uses something, and it doesn't have to be an inherently dangerous object. It could be a ballpoint pen. It could be a boot, an ashtray. It's the manner in which it is used makes it dangerous. So if there is some type of object that is weaponized and it is used with intent to do bodily harm, that is punishable by up to 10 years, a fine, or both. We have assault by striking, beating, or wounding. This is not in the Major Crimes Act, so we are only going to use this offense typically if we have a non-Indian person and as a defendant and an Indian person as a victim. I use this a lot in domestic violence cases because we don't have a misdemeanor domestic violence statute in the federal system. Instead, we have assault by striking, beating, or wounding. And what I would try to pay careful attention to when I was writing the indictment for one of these offenses is to make sure that I put in the indictment language what the relationship was between the parties. So if it was John Doe, a non-Indian, did assault by striking, beating, or wounding Jane Smith, an Indian person, and his girlfriend. That may become important later on if John Doe reoffends. So we want to be able to know what is the relationship between the parties. So this was when the Violence Against Women Act was amended in 2013. This particular crime was increased from a 6-month maximum sentence to a 1 year. And again, this is what we typically use for misdemeanor domestic violence in the federal system. Assault resulting in substantial bodily injury. This is injury that's of a temporary nature, and the particular victims that we can use to charge this, if it's spouse, intimate partner, or dating partner, and if we have a person, our victim is under the age of 16. This is a 5-year offense, 5-year maximum sentence. This was amended in 2013 when VAW was passed, and that's when we had spouses, intimate partners, and dating partners that were added. Because before that, I would get a lot of questions about, how come the feds only show up when somebody's almost dead? Well, we didn't have a statute that we could charge if we had a Native American defendant and a Native American victim until we had assault resulting in serious bodily injury. So this amending this and including spouse, intimate partner, and dating partner, having this more medium level felony, the hope is that we can get in these families sooner and get them some assistance and hopefully avoid the fatal or near fatal episode. Assault by strangling or suffocating. This was brand new in 2013. So now we have a strangulation statute in the federal system. It applies only where there's a certain relationship between the defendant and the victim, and that's being a spouse, intimate partner, or dating partner. And it also covers attempts to strangle or suffocate, and it is punishable by a maximum sentence of 10 years. And what is really important, and if you're doing some systems change work in your community, or you're working on a coordinated response and you're thinking about writing a strangulation statute, not that the feds have it all figured out, but this definition I think is very helpful. So we have to prove beyond a reasonable doubt that the defendant intentionally, knowingly, or recklessly impeded the breathing or circulation of blood of a person by applying pressure to the throat or neck. And this is the important language which is underlined. Regardless of whether that conduct results in any visible injury or whether there is any intent to kill or permanently injure the victim. So we don't have to prove injury, and we don't have to prove intent to kill or permanently injure. What we need to show is that the breathing or the blood flow in the neck was obstructed. So that not having to prove injury is really important, because as you all likely know, you can strangle someone to death and leave no external visible injuries. Suffocation, same thing, no requirement to show injury, and that requires proof beyond a reasonable doubt that normal breathing was impeded by covering the mouth of the person, the nose of the person, or both. So we have had many cases now that have been prosecuted in the federal system using the strangulation statute. But the earliest one, the first one we actually had when the statute was passed, was in Montana. The case occurred on the Blackfeet Indian Reservation, and the Assistant United States Attorney who prosecuted that case, his name is Ryan Weldon. He's a terrific prosecutor. And in this particular case, the defendant strangled his girlfriend. He used some words of intent, like, I'm sorry, I'm going to need to kill you. She was able to free herself, run out of the house. She got right into her car and started driving towards law enforcement. So we had an immediate outcry in that case. The police were able to get pictures of her. She was seen by a doctor, which it's best practice to have strangulation victims seen by a medical professional. The doctor documented a substantial risk of death. The defendant confessed and also pled guilty to 1 count of strangulation. So that particular defendant got a 30-month sentence and 3 years of supervised release. So that's the case of United States versus Zachariah Crawford. So you could see there. The next case, this is the first case that went to trial. So Crawford was pled guilty. This case went to trial. And this is also a Blackfeet case, and also Ryan Weldon prosecuted this one. And in this particular case, the defendant and the victim were out the night before socializing at a party. He became jealous of attention that he felt she was getting from others. So when they got back home, there was an argument, and he strangled her multiple times, picked her up by her hair, hit her on the head. She was able to get into the bathroom. He entered the bathroom, grabbed her by her legs, dragged her back to the bed. So she was strangled to the point of unconsciousness multiple times. The next morning, she was able to get out of the house and told her mom what happened, and she was taken right away to the hospital. So there are some great quotes in the reported opinion out of the Ninth Circuit on this. Recent studies suggest that Native American women experience certain violent crimes at 2.5 times the national average. Particularly pervasive among violent crime is non-fatal strangulation. Nearly half of domestic violence victims report being choked. So if you are a prosecutor and you're writing briefs, this may be a reported opinion that you may want to look at, because there are some great statistics that are cited in the opinion. Ryan charged 1 count of strangulation using the new statute, and he also charged assault resulting in serious bodily injury and alleged that the strangulation created a substantial risk of death and resulted in extreme physical pain to the victim. Law enforcement did a great job in this case. They took pictures of both the victim and the defendant. So pictures of the victim, you can see some scratches up under her chin, kind of in the hollow of her throat, on her neck. I can see some marks behind her ear, where perhaps her earring created some bruising when she was struck. And also pictures of the defendant. Now, the defendant argued in this particular case self-defense, that the victim was attacking him, coming at him, and he was only defending himself. And so as you see there, she has visible injuries. You don't see any visible injuries on his face or on his neck. Police did a good job of taking pictures of his arms. Typically, when we have somebody that is being attacked, they instinctively put their arms up in front of their face to block the blows. And sometimes we see what are called defensive wounds on the back of their arms, where they have been struck by somebody who is attacking them. We don't see, at least I don't see, really many injuries to his arms. I do see some discoloration on his knuckles. Whether those are attributed to the assault perpetrated on the victim or not, I don't know. But you can see that the marks all appear to be on his hands and knuckles. So there was an IHS doctor who testified as an expert in this case, and he wrote a terrific report. It's less than 2 pages. It's written in very easy language to comprehend, and it gets right to the nub of the issues. So he said that strangulation blocks the flow of blood and oxygen to the brain, depriving the brain of oxygen and blood. When the brain is unable to receive blood and oxygen, brain damage and death are likely results. And this was important because Ryan charged assault resulting in serious bodily injury and alleged a substantial risk of death. He also alleged that the victim would endure extreme pain. And you can see here that the IHS doctor, in his report submitted to the court, said if the victim survives strangulation, he or she will likely endure a high level of pain. When treating strangulation patients, many times there can be no signs of trauma to the neck, and then he explains why. So it's just, I think, a terrific example of expert written opinion in a case. So as I said, this was litigated at trial, 2-day jury trial. Defendant was convicted of the strangulation charge. The jury hung on the assault resulting in serious bodily injury. He got 32 months imprisonment. He did appeal to the Ninth Circuit. So this is also the first reported opinion we have using this new strangulation statute. His issue on appeal was that the trial court made a mistake and that they didn't instruct the jury on intoxication as a defense to specific intent. And before this case, there had been no appellate court that had weighed in on whether this new strangulation statute was a general intent or a specific intent crime. And the court said it was a general intent crime. Therefore, the trial court did not err by not instructing the jury that they could take into account the defendant's voluntary intoxication. So Violence Against Women Act 2013 amended the Major Crimes Act, and now all felony crimes under Chapter 113, the felony assault statute, all of them are now incorporated into the Major Crimes Act, which means that the federal government, if we have a Native American defendant and a Native American victim, and we're in a non-public law 280 jurisdiction, we can charge all of these offenses in federal court. Another important statute, the domestic assault by an habitual offender. This was created by an earlier version of VAW, and the statute is found at 18 United States Code Section 117. And this essentially says if you have a defendant that has committed a series of misdemeanor domestic violence crimes in their tribal community, and those are offenses that would be subject to federal jurisdiction, or an assault, sexual abuse assault, or interstate domestic violence, or serious violent felony against a spouse or intimate partner, that subsequent crime becomes chargeable in federal court. And this is important because we see defendants who are recidivists and they're committing, crime after crime, misdemeanor domestic violence crimes in their tribal community, and the tribal court may be exasperated trying to craft some type of remedy that gets them to stop. The victim is terrified, the victim continues to be harmed, children may be harmed, the community certainly suffers, but yet this defendant is just a revolving door in and out of tribal court. So having this option to now take that case in federal court gives a little bit bigger hammer over that defendant. So it's a 5-year maximum sentence unless the victim has endured some type of substantial bodily injury, then it goes up to 10 years. So this case, the Michael Bryant Jr. case, went up to the Supreme Court in 2016. So I mentioned essentially this is making the third or subsequent misdemeanor DV case committed in Indian country a federal crime that brought with it the issue of those cases that were handled in the tribal court are under the Indian Civil Rights Act. So if you're charged with a criminal offense and you're looking at serving time in a Western or Anglo court and you're poor, the court is going to appoint a lawyer to represent you at the court's expense. In tribal court, it's the Indian Civil Rights Act that applies. And what ICRA says is that you have a right to counsel, but counsel that you pay for. Now, some tribes do provide law-trained licensed attorneys for every defendant that comes into tribal court, but others use a lay advocate or a lay counsel, or the defendant has to hire their own attorney. So how the Bryant case got to the Supreme Court is in the Ninth Circuit. He was charged in the District of Montana with this habitual domestic violence offense, and he argued that was improper because he hadn't had a law-trained licensed attorney that represented him in tribal court. And this was a Northern Cheyenne tribe in Montana. And this case, same issue had been litigated in some of the circuit courts. There was a split. So now we've got the Bryant case. It goes up to the Supreme Court. And so the issue in the Supreme Court was, is it permissible to use uncounseled tribal court convictions? So uncounseled meaning there was no law-trained licensed attorney representing the defendant. Could those be used to establish the habitual DV charge in federal court? And the Supreme Court said yes. The Supreme Court also said that the habitual DV charge was tailor-made for a defendant like Bryant. You could see there in the first bullet, he had a record of over 100 tribal court convictions, including several convictions for domestic assault. And when you look at the convictions that he had for DV, they were egregious cases. Between 97 and 2007, he pled guilty on at least 5 occasions in tribal court to committing domestic abuse. One time he hit his living girlfriend on the head with a beer bottle and attempted to strangle her. Another time, in a different girlfriend, he kneed her in the face, breaking her nose, leaving her bruised and bloodied. So those aren't what I would really call misdemeanor crimes. They were very serious domestic violence crimes. But over 100 total convictions he had in the tribal court. So in 2011, he was arrested again. In February, he attacked his girlfriend, dragged her off the bed, pulled her hair, repeatedly punched and kicked her. Then 3 months later, he assaulted another woman. So very egregious record. And the Supreme Court said because Bryant's tribal court convictions occurred in tribal court and tribal court proceedings that complied with the Indian Civil Rights Act, they were valid convictions, and using those convictions as part of the habitual DV charge in federal court was entirely proper. So very important decision. So that habitual domestic violence charge, if you've got cases where you've got a defendant in your tribal court that is repeatedly committing additional acts of domestic violence, you may want to consider reaching out to the U.S. Attorney's Office to see if this particular charge applies. And if you don't know who the tribal liaison in the U.S. Attorney's Office is, you can reach out to me and I would be happy to provide that name and contact information to you. So let's spend just a couple minutes talking about domestic violence and prohibited possessors. So in the federal system, we have the Gun Control Act, and we have certain categories of people that are prohibited from purchasing or possessing guns or firearms. Those individuals who have been convicted of a felony, if somebody is an unlawful user or addict of controlled substances, and for our purposes today, the last 2 categories there, and there are more categories than I have on this page, but those who are subject to a qualifying protection order and those who have been convicted of a misdemeanor crime of domestic violence. So here is applying the Gun Control Act to the Michael Lee Long case. This is a case, South Dakota, Rosebud Sioux case. So this particular defendant has already been convicted of a misdemeanor crime of domestic violence. So under the federal law, he is forever barred from purchasing or possessing a firearm, forever, once you have a misdemeanor conviction of domestic violence. So he assaulted somebody, threatened them with a gun. It was at a party store. There were other people in the car that witnessed what he did. So he was charged with multiple offenses to include assault with a dangerous weapon, simple assault, a violation of the Gun Control Act, and using a firearm during and in relation to a crime of violence. So he appealed his conviction because he said in the underlying tribal court case, that case, domestic violence case, which led to him being a prohibited possessor, he wasn't represented by a licensed law-trained attorney. And what the court did is basically took the Bryant analysis for the habitual DV charge and used that in the Gun Control Act and said that you can use, you can see on the slide there, they reference the Bryant case explicitly, you can use uncounseled tribal court convictions to support a charge and conviction in a prohibited possessor case. And that is because tribes follow the Indian Civil Rights Act, and there is no requirement to provide law-trained licensed attorneys. And because in his underlying DV case, the Indian Civil Rights Act was followed by the Rosebud Sioux Tribal Court, it was perfectly permissible to use that domestic violence charge in federal court. So really, really important. So now we've got those uncounseled convictions can be used to support habitual domestic violence charges. And now also we have it being used to support a Gun Control Act violation. And we know that guns, unfortunately, are a significant issue with domestic violence cases and sexual assault cases. I mentioned a prohibited possessor is if somebody has a qualifying protection order issued against them. And that can be out of tribal court. In this particular case, Freiberg Jr. Had a protection order that was issued against him out of the Tulalip Tribal Court. He was served with that. He didn't show up when he had a hearing. So an order of indefinite duration was entered by the Tulalip Tribal Court. Freiberg never sought to have the order removed or modified in any way. So he was not allowed to have guns or ammunition. However, even while this protection order was in place, he acquired several firearms. So ultimately, the U.S. Attorney's Office in Seattle filed a complaint against him concerning a Beretta Storm handgun. And again, he had that, possessed that, even while a qualifying protection order was issued against him. And then 6 additional counts were charged against him in federal court concerning 9 additional firearms. So this is a picture of Freiberg taken off of the news, and why this case is so important and why we want to talk about we want to keep firearms out of the hands of people who shouldn't have them is this is his son. And his son took that handgun to school and unfortunately murdered a number of his classmates and killed himself. So the Tulalip school shooting got a lot of media attention a number of years ago, a really, really tragic case. And his dad was convicted and was sentenced to 2 years in prison for this case. And then 3 years of supervised release, which effectively is like a probationary period once he was released. So, just a tragic case. So how do we figure out if people are prohibited possessors? Well, it all comes to records and information sharing, which is the last thing I want to talk about today in the time that I have left, and why it's so important that we work together. Where I started is we're a team. We share information. We work collaboratively on investigations. We certainly do those in a reactive manner. When crimes occur, we work very closely, tribal law enforcement, federal law enforcement, tribal prosecutors, federal prosecutors, victim advocates, name the discipline, we should be working collaboratively. But we also have the ability through information sharing to work proactively to prevent bad things from happening. So we have a federal NICS system, and that has to be accessed by federally licensed firearm dealers to determine if John Doe, when he comes into Cabela's to buy a firearm, if there is something in his record that prevents him from legally purchasing a firearm. So NICS has, there's 3 days for them to run that background check. And the NICS system looks at NCIC records on wanted persons. There's a national protection order file there. They run through that. They look at criminal history records to see, does this person have a domestic violence conviction entered against them? So anything that would flag that person as a prohibited possessor. So again, I mentioned the protection order file. It's important, like in the case with Freiberg, that to the extent we can, we get tribal protection orders entered into this national database, because this is what is going to be checked if somebody goes to purchase a firearm, or if a victim goes, gets a protection order from Tribe A and then is visiting 3 states away, family members, and the defendant follows her there. local law enforcement is more often than not going to look at NCIC and see what records are in there. But we don't have, I mentioned 574 different federally recognized tribes, and we've got much less than that are putting tribal protection orders into that NCIC file. So here's the statistics that I have over the last number of years. So we start August 2012, we had only 207. And as you can see there, the number has gone up fairly steadily. The last number I had is April 1st, 2021. We had 1,236 tribal protection orders entered into that file. So if we were all together in one room, I would ask for a show of hands, who thinks that there are a heck of a lot more than 1,236 tribal court protection orders out there? And I think universally, everybody's hand would shoot up. And I know sometimes tribes are reluctant to enter records into federal databases like NCIC. Sometimes there have been problems historically with states giving access to tribes to enter their orders into NCIC, but it is really important. I, as a prosecutor, can do my job much better if I can access the database that is used by most law enforcement agencies, and be able to look at what is somebody's arrest records, what are their conviction records, is there a PPO, because all of that is going to help me make requests of the court for conditions of release, or to ask to have somebody detained pending trial. In the case of domestic violence, it may influence what charges I'm able to bring. So I feel very strongly about the need to share records, because if this NICS search turns up no PPOs, turns up no domestic violence convictions, and they've got 3 days to do it, to do this search. If nothing shows up, then the defendant is going to be able to purchase that firearm. And you know, if the licensed firearm dealer has no information that the person is a prohibited possessor, then they're going to end up selling the gun to that person. And we know, based on the cases you have likely all worked, and that I have certainly worked, a firearm in the hands of a batterer presents a significant lethality risk for victims of intimate partner violence. The first homicide case I ever worked as a baby prosecutor was a woman who was shot in the chest by her defendant. Her husband shot her in the chest with a .38 revolver. So it was that vision of her stretched out on the floor on her back in the living room with the kids' toys and the kids' pictures is, you know, forever etched into my mind. And that was many, many years ago. So I think that there is a lot that we can accomplish by working collaboratively and sharing the information that we have. Now, for those tribes that have difficulty accessing NCIC through the state, and that is a legitimate issue for some, the Department of Justice has its TAP, or Tribal Access Program. This is just about every year there's an application process. Unfortunately, this year's was ended on August 31st, but there is information on that Tribal Justice and Safety website that I gave you about the TAP program, so that if you are not accessing these records, or you want to and you've had problems with the state, this gives the tribe a direct access through DOJ to the NCIC portal. It comes with a kiosk, hardware, there's training involved. It's a terrific program. And many states have, or excuse me, many tribes have already taken advantage of it. So I hope that you will give it a look. And this is my last slide, because after talking about sad stuff for a really long time now, for almost 90 minutes, it's nice to end with picture that makes you go, oh, that is so sweet. And I think that is a sweet picture. So if you have any questions, please do not hesitate to contact me. I'm very responsive to email, and I would love to hear from you. And if I can provide you any assistance, I would be happy to do so. Thank you so much for your time and attention today. And thank you for the work that you do in your communities to make victims and survivors safe. Thank you. Jill?
Yes, thank you so much, Leslie. And I have a smile on my face now because of that beautiful sloth photo. So I really do appreciate you ending on that sort of a note, because it's very heavy stuff. And I can only imagine being in the work as you are. You have to bring up the sloths once in a while so we can remember to be light. So I very much appreciate that. It looks like Holly put a link in the chat for those of you to look at the TAP program that Leslie was talking about. There's so much information here within this PowerPoint and within Leslie's session here today. So grateful for you, Leslie. You took us all around and giving examples of the case studies and how those codes are implemented in the different ways that we can understand that better is very helpful. So I appreciate that immensely. For participants, I do want to mention that we will be sending out a recording of Leslie's presentation. So look for that in your inbox. If there's any other questions, we are right at time. So if there's any last minute questions, I can definitely bring those up. Otherwise, I will again say thank you to all of you for attending today. And thank you, Leslie, for taking time out of your day after a big holiday to join us and share all this wonderful information.
Thank you. It was my honor.
Wonderful. It looks like we just have a nice thank you in the chat. So be well, everyone. Enjoy the rest of your Tuesday and keep that sweet little image in mind, as I will too. Take care, everyone. Thank you.
Thank you.
Bye-bye.